Hello, everyone, and welcome to On Crime and Punishment, a podcast from the Center for Criminological Research at the University of Alberta. Thank you so much for joining us. In this episode, Dr. Kevin Haggerty, one of our faculty members, will be talking with Dr. Nicole Myers, an assistant professor of sociology at Queen's University, about the changes to the bail system in Canada that have resulted from the COVID-19 pandemic. And as always, please remember to subscribe to the podcast. It's available through Apple Podcasts, Google Podcasts, and Amazon Music, and most other podcast apps. You'll be able to find it in those as well. Also, follow us on YouTube, youtube.com/c/Center for Criminological Research. We have some great content coming out this summer that you won't want to miss.
Welcome everyone to the next installment of our discussion with Canadian criminologists about trends and dynamics related to COVID and the criminal justice system. We're very happy today to have Dr. Nicole Myers, who is a professor of sociology and criminology, I believe, at Queen's University. And she's going to talk to us about a range of things related to courts. So thanks, Nicole. Appreciate it.
Oh, thank you for having me.
Maybe just a good place to start is for people who might not know you or know your work. Just give us a sense of who you are and the types of things that you're interested in.
All right. Well, as you did indicate, yes, I am an assistant professor in the Department of Sociology at Queen's University. I'm a criminologist by training. My interests have primarily focused on bail and pretrial detention, but certainly expand much more broadly to that, to general criminal court processing, sentencing, and the administration of justice. And here I mean sort of charges against the administration of justice, but also the way we administer justice in that court process, as well as sort of the surveillance and social control we have in the community that's tied to that court process.
So I think we're going to talk a lot about courts in terms of the big picture. We're going to move into talking about COVID related stuff. But from your research, I mean, what are some of the big concerns in Canada right now relating to sentencing, court processes, that kind of stuff?
I think one of our most pressing issues, and why I think I've spent so much time studying bail, is that we have more people in our provincial jails that are to be presumed innocent than are in our provincial jails having been convicted and sentenced to be there. And those populations crossed over for Canada generally in 2005, for Ontario in 2001. And this has continued relatively unabated. The most recent data shows that Ontario and Alberta are indeed neck and neck, with close to 70% of our provincial jails holding in pretrial detention. And I think sort of related to that then, and sort of my concern around that is thinking about the kinds of conditions we impose on people when they're released from custody, and how those conditions effectively criminalize non-criminal behavior, can be really difficult to comply with, especially for a long period of time. And so in many ways, in my view, release on bail actually ends up sort of facilitating more detention by people being brought back in for failing to comply. I think we then see those kinds of issues spill all the way through the criminal justice system, as what happens at the bail stage is incredibly important for plea bargaining for sentencing.
So going for your first point, maybe for people who aren't familiar with kind of the vagaries of Canadians' legal system, can you explain how it is that we have more people, innocent people, incarcerated than people who've been convicted? How have we ended up in that kind of a situation?
Oh my goodness, isn't that the question? I mean, unfortunately, there's not one single answer. It's a lot of different things. It is police discretion, where they have the power to release and they can impose conditions. But about half of the time, at least in Ontario, where I'm most familiar, they're holding people for a bail hearing. And so they're waiting until they come to court. In court, we have a bit of a risk-averse mentality. And I think that we see that risk aversion with police as well. So there's nervousness or reluctance to be the one to make a decision out of a legitimate concern that maybe this decision turns out badly and this person goes on to do something really big and really serious, and people being reluctant to be the individual to make that decision, and also thinking more broadly about what that does to the reputation of the criminal justice system when these kinds of things happen.
Right. So a mix of things often related to sort of risk averse institutions.
Absolutely. And sorry, I was going to say one sort of last piece in the bail process. I mean, the Crown being such a major driver of the process, seeking, supervision or seeking other kinds of conditions and meeting those kinds of requirements can take a lengthy period of time. So you have people in pretrial detention who have had their bail denied and they're going to stay there until their charges are resolved. But you have a lot of people that are there simply just waiting for the decision. They're not going to be there long, but nonetheless, they are still in custody while they await.
Right. So transitioning to sort of the COVID situation, I know you have done some preliminary research in this area, but I'm intrigued both about, what you've been finding, but generally your sense of general trends relating to the courts. And I'm just curious, what do you see have been some of the more interesting, surprising, disconcerting developments kind of related to COVID?
Yeah, I think sort of the background to that is two incredibly important pieces. One where we see custody as being an inherently risky place. And so in the context of a pandemic, we then see that there were sort of some serious efforts to try to engage in some decarceration and try to remove people from this space. Now, did it go perhaps as well as it could? No, but there were efforts in place to try to, and all of this came to that recognition that in detention, you can't engage in physical distancing. There is not proper personal protection equipment. And in particular, in the context of both remand and provincial institutions, you have people funneling in and out of these spaces a lot, which means there's not only a lot of contact within the institution, but they're bringing that risk back out into the community when they return. The other thing is that the court has always operated in person, where traditionally speaking, we would require everyone to be physically present in court to have their case heard. And in the context of a pandemic, when the courts shut down, you had an institution that has in many ways been resistant or slow to uptake some basic technologies as email and video conferencing or conference telephone lines. And so that real and serious struggle of trying to uptake those kinds of technologies in a really quick fashion. And so as you can imagine, it was not smooth.
So do you have any sense of what that looked like in practice?
Yes. So the only way to observe the courts, or at least bail court, because everything's happening remotely, is to call in. And that in itself ended up being replete with challenges. The difficulty of finding this phone number that you're supposed to call. It's not publicly or readily available. That even once sort of into the space, you may not be let out of that sort of waiting room and allowed into the actual hearing. So you're sort of perpetually waiting to be let in. And then other challenges around poor sound quality, people talking over top of each other, people coming in and out, an inability to know who's talking. And so it was really difficult to sort of follow what was happening and add in some dropped calls, and you're left quite frustrated.
Has this been acknowledged? I mean, is this something that they're recognizing that this presents a problem, or does life go on as normal, or how?
I wish I knew the clear answer to that. I would like to think that this is something of a high priority and we would be seeing improvements made, but at, what are we, 11 months in now? And bail court didn't go back to in-person even when we did open restrictions. So they've stayed in this virtual format, yet the technology has not necessarily been improved in the way that you'd hope. I also was just reading about court reporters, however, talking about how incredibly difficult this is, as their jobs are to record the proceedings and to generate transcripts, and that there are very big chunks of that record that they can't hear. And we can see this being enormously problematic, that this particular tool, this is the only thing we have that lets us know what transpired in court on a particular day.
Yeah, I mean, we'll get back to the realities of COVID. But I was thinking, as a researcher, I mean, one of the appeals of studying courts is that major parts of courts are open. You can go in and you could observe. I mean, what are the implications for doing research now?
I think the implications are enormous. I mean, the shuttering of the court sort of really touches at a lot of fundamental principles we have about an open court system. This idea that it's to be open not only so people have their day in court and test the allegations and the state has to demonstrate it, but also as a really important check on state power, where this is our opportunity to hear, what has the state done? And are they able to demonstrate beyond a reasonable doubt that you did or did not do something? And so by shutting everything down for public health reasons, we have effectively precluded the public, researchers, the media, I think, gets some greater access, but still not that same experience of simply walking into a courtroom at any time for any reason. It's simply not available. And in terms of thinking about long-term research, is having to think about, is there ever going to be a time when these things are going to be really widely publicly available, or are you having to apply and request permission to get access to recordings, which are, when you're asking permission, one knows that might not be granted.
Right. Yeah. I mean, there's some tensions there with that standard axiom that justice has to be seen to be done. I mean, it just seems like what you're describing is it's very hard to actually, if you're not a player, it's hard to actually see what's going on. That's interesting. Do you get any sense of whether prosecutors or defense attorneys are kind of how they're managing this?
I think sort of in the beginning, very stressed and overwhelmed, like anybody else, this, trying to then be able to hold these kinds of hearings from your home or from wherever. I think you end up with a bit of both. In some sense, there's improved efficiencies, particularly for defense counsel. They're not running around to multiple courtrooms or different courthouses, and they're in the same place, but you still have the same challenges of trying to get all the players on the line at the same time. That I think some of the efficiencies are a little bit overstated, and that in listening to what's happening in court, you would still hear long delays of trying to get an accused in custody from their cell to where to have their court appearance. Difficulties with sureties calling in to help bail somebody out, and their call being dropped and not being able to reconnect.
So I know from some of the prison research, I mean, there are in lots of locations or some locations, these virtual courts that people attend while incarcerated. And did they just piggyback on some of that infrastructure, or did they just cobble something together frantically?
I think a little bit of it was piggybacking. I mean, there are other jurisdictions in Canada that have really moved to this virtual model long ago and have a lot more experience doing these kinds of things. Ontario did hold sort of some video hearings, often just simply remands, not where you were then sort of actually doing something meaningful in a particular case. And so I think that was part of the challenge, is the technology was simply not already in place, and where it was in place, it's that connection to the detention center or to the police detachment, that it can be really difficult to be able to properly see and hear what's happening.
So there's lots of different, I don't know what you would call, different types of people, that this affects people differently. I'm just curious if you get any sense of how some of this might affect different categories of individuals who end up going through the system.
Absolutely. I think that we look at a system that has always been difficult for many folks, and then you think about sort of the layers of difficulty that this presents for others. So, I mean, here, if I'm thinking about Indigenous people or racialized folks, we can think a little bit more broadly about differential infection rates that we've seen in some communities. You can also think about enhanced vulnerabilities that some people have on account of poverty, inability to distance from folks, more densely housed, underlying health conditions. And then sort of tie that together with these often being communities that are over surveilled, over policed and over monitored. And so that you're sort of taking some of the issues we saw before and really just adding onto those.
Right.
With other groups of people I think about have come to mind are women, and we know that women are one of the fastest growing custodial populations, and we see women entering pretrial detention, and we get to this tension of traditionally a lot of women being in primary care roles, and what this then means in terms of being arrested and having restricted conditions, but layering on the challenges of everybody being home, needing to take care of schooling from home or working from home, the ability to quarantine and isolate, all of these being particularly problematic given a lot of the gender roles that people are living within.
And I guess one of the things I'm interested in is kind of, obviously, as you started out with, a lot of this has become technological. How does this feed into concerns about sort of the digital divide with people's infrastructure, and not just the technological availability, but competence, familiarity, all that kind of stuff?
And I think that's such a huge point. We often start with this assumption that having a simple access to these things is readily available, and well, for many it is, but that sort of precludes those who it's not available. And I don't know that we've really carefully thought about how to best reach those folks or how to facilitate this happening where at least before, so you showed up, and I mean that came with other barriers, but this divide, and whether it's differential reception and internet access, having the necessary hardware to be able to do this, but needing to be mindful of what you pointed out, the competence, like the capacity and the ability to use these kind of technologies, particularly if you're unfamiliar, you're stressed, and feeling that there may be serious consequences to you if you sort of fail to do this. And I think the other thing that needs to be mindful of is that it's one thing for someone to be able to have a quiet, direct conversation with the court that completely ignores what that means for people who have children at home, for people who are precariously housed and living in communal spaces, where you can imagine a court being, again, understandably frustrated because maybe they can't hear, they're being interrupted, but that lived reality of people trying to do these things remotely has to be considered.
So the logistics of this, would this be hypothetically someone in their home zooming in or whatever, or whatever the equivalent would be?
Yes, that's largely been what it is. I've heard a lot of people talking about doing it from their cars or
Right.
whatever. Outside of I mean, some courts have done different things where they've allowed like very skeletal staff to appear, but the expectation is that most people are calling in, and it may simply be a room with a justice and a clerk who's keeping track of everything.
Yeah, I'm just thinking out loud as we're talking here. I mean, this is there's always questions about stigma and how people are interpreted by their appearance. This adds a whole other layer of interpreting people's lives and life conditions if you're viewing their home essentially, or whatever passes for their living conditions. I mean, that's a whole other, I don't know if it's necessarily stigmatizing, but it's an interesting new bit of interpretive material that becomes part of this process.
Well, yes, and we think sort of about this idea of how this is allowing sort of the eyes of the state into private spaces. I've made that argument in the past about the use of surety supervision, that they're acting sort of as, as third-party police, and now they have to report to the state that they get access to private spaces the state wouldn't have access to. And now we have a computer. Well, that's even better. And that being able to capture someone, how you talk to somebody, whatever's going on in your background, things that you may not control, or again, people that perhaps aren't in an indoor space, whether you're walking and talking it into your, like, what does this look like, and then what sort of assumptions are we drawing about people from how they may present in a video context?
Yeah, that's really fascinating. In terms of one of the real developments in the last several years has been a proliferation of new specialized courts. Is there any sense in which the COVID, what we're talking about, some of these technological things or some of these issues about the invisibility of the process, does this play itself out differently in any of these courts, or is this something we know anything about yet?
Yeah, we don't know a great deal about it. I have heard sort of murmurings that some of these specialized courts aren't operating. And so for example, I've heard in some locations the Gladue courts aren't specifically operating, I guess then meaning that you don't technically need a Gladue court to be considered.
So maybe we should just pause. I'm not sure kind of that everyone will know. Maybe you can just remind everyone what a Gladue court is.
Yes, thank you. Gladue. So these are special courts that were developed after the Supreme Court of Canada's decision in the case called Gladue. And it was really about trying to provide a courtroom that was going to be more focused and more conscious on the colonial histories and history of intergenerational trauma that Indigenous people have faced. And so in establishing a separate court where there are enough people coming through, there are other measures that are put in place to try to be more culturally sensitive.
Right.
However, the idea is that any court can be constituted as a Gladue court by simply the participants, making some adjustments to how they approach the case.
Right.
But so we have the specialized Gladue courts. We can also think about drug treatment courts and domestic violence courts, community courts. There's sort of a variety of specialized courts. And the one thing that comes to me around all of these models is that it requires regular contact with the court. Anytime you're into one of these specialized pieces, you're generally reporting to the court with much greater frequency than people in the more sort of regular traditional process. And so I'm curious about how it is that's being sort of shifted and changed. These courts also very much invoke or bring in community sort of agencies and members. And again, I don't know how their access to these proceedings is being facilitated in these spaces.
Right. Okay. That's important. Now, sort of, there's lots of challenges here. Is there anything big picture that we might think, or is there any way to conceive that positives might come from this, or something that might be beneficial in terms of planning or rationalizing or something like that?
Yes, I mean, I think if we had to sort of think about, what could be, I mean, are you asking sort of what could be done differently or what kind of message to take from this?
Yeah, I mean, this is a pretty remarkable transformation in a very, very old process. And sometimes you learn things by doing that. Have we learned anything that might be useful in terms of improving things, or alternatively, have we learned anything useful about we absolutely do not want to do this? That's another kind of lesson.
Yeah. So I mean, I think some of the things that need to be remembered here are sort of an uptake of technology a little sooner. I mean, some of these things have been being advocated for a long time, and if these things had been in place, we could have imagined this going a bit smoother. I think we need much greater transparency here, whether the transparency in terms of access numbers, so that people could call into the court if they're inclined to do so. I think also there's been very limited press releases that talk about reductions in the pretrial detention population, but no discussion about sort of how was that achieved, who's being let out, why have we seen this drop, and reasons we need to know is to understand how we can try to sustain those things. But given that there was almost a 30% drop in those in remand, what to me this tells us is we have the capacity to reduce our reliance on incarceration. That in times of an emergency, a public health emergency, we could apparently do the impossible and let all kinds of folks out. And so I think what this means is that not only should we be pursuing more aggressively decarceration, but is also thinking about who we're letting having go in there in the first place, and that is really part of the effort of keeping people out of custody.
Now, I haven't seen these statistics yet. Do we have statistics now on sentencing patterns over the last year in terms of whatever that might look like?
Not that I am aware of. I think we're still a little bit early for some of those things to come out. The stuff that I've heard were through special releases coming out from Statistics Canada, because otherwise, I mean, we're usually a year to 2 year delay in the release of data. So it will be interesting. I've made some inquiries to folks about how they think issues around time to trial are going to be dealt with, how we're going to be providing credit for pretrial time, and nobody seems to have any real impressions that this is going to result in significant differences. But I'd be very interested to see, particularly around the arguments around detention, as to whether you need, because I mean, the courts have had multiple decisions of trying to figure out, do we think about the vulnerabilities that an individual has and them needing to demonstrate that custody is a particularly dangerous place for them, or this being applied in a more blanket way that it's dangerous for everybody. And on that's simply enough that you don't have to demonstrate a personal enhanced riskiness.
Right. And if this plays out in the remand population with a reduction of shorter sentences, the grind that goes on in remand of people, maybe they've, I'm hypothesizing here, but might be that those people have ended up somewhere else instead of that revolving door of very brief sentences. But again, I'm speculating. We'll have to wait and see.
Yes. I think it'll always be that tricky piece too, because most sentences that we impose are really short. And so it will be interesting to sort of see if perhaps that's enough of an impetus to push more community-based sanctions, acknowledging that the risk of going into custody, why are we now sentencing someone there for a week or 30 days or something like that?
Right. So sort of coming near the end here, I guess the thing that I'm always interested in, coming back, abstracting up to the discipline, I guess, are there things that you think that criminology might have learned from this that maybe we didn't know already? Or the other side of that, are there things that the whole COVID situation and relationship to courts and sentencing, did it confirm things that why we knew this and this just really brought this home for us?
Yeah, I mean, I don't know that anything I have found would be terribly surprising, in the sense that I think it continues to be really difficult to get access to good data to answer all of the kinds of questions that we very legitimately have, whether that's in terms of it being made available at all, or the time lag in getting those things. I think also is the sense that the system can change, which in some ways makes sense. I mean, that's often what people's work is targeted towards, is trying to make adjustments, but that change is often resistant, bumpy, and real genuine concerns of sort of returning to a status quo, that as particularly in the context of a pandemic, how so those initial fears and anxieties may have really dramatically shifted behavior, and then how we really sort of start settling back into the standard way of doing things. And so my sense then is that even when things appear to change, they may very well be staying pretty close to the same. And I'll give an example of that. Looking at, I observed over 80 days of bail court in Ontario during the pandemic. And when I compare that to some of my earlier data, it looks remarkably similar. The only real sort of adjustment seemed to be a reduction in the use of sureties, and we don't know if that's on account of the Supreme Court decision in Antic or if that's, in a response to the pandemic. And so I think then what it says is that we can have enormous change all over the place, but at its core still not be necessarily making as much change, or that change is temporary.
Yeah, I guess this is the real, $10,000 question is, are the people who are operating the system seeing this as an opportunity to sort of introduce some changes that kind of might be beneficial, or is this just a holding pattern until we can return to kind of the good old days of how things used to work, not knowing how inefficient and ridiculous that was?
Well, and it is, all of this virtual, all this uptake of technology has incredible potential. It really could streamline so many things. Why do we have everybody come to court all at the same time? This has the capacity to particularly help in remote or Indigenous communities, where this could facilitate enhanced access and remove some of the barriers of, going to and from court. Yet at the same time, sort of harking back on some of the work by Webster in 2009, where she looked at video remand courts, was that all this ended up doing was creating more adjournments and more processes that then had to happen, because there seems to be something different about an individual standing in person directly before you and this disembodied voice on the phone.
So maybe the human being there provides a sense of urgency that we have to deal with this, or this can't be postponed yet again. I guess this area better than me. When I think of your area, I think the figure who sort of dominates the literature is Malcolm Feely, and sort of the process is the punishment. I guess to conclude, do you see this as contributing to that ongoing problem of the process being the punishment, or do you think some of that, the punitive aspects of the process might be rectified or addressed?
I guess it's an interesting question. I do think the process is the punishment. I think, at the end of the day, it's a small proportion of people that are ultimately convicted and sentenced to jail. So we're looking at, sort of gradations below that, and that with uncertainty as to whether we're going to convict somebody, we extract something through this process. And what I sort of worry about is, thinking about the way this will generate new and different ways that the process now punishes. So here I'm thinking about defense counsel's challenge with developing rapport with somebody that they never actually see in person. I'm thinking about the challenges of facilitating confidential conversations even with a client, and the lack of infrastructure available to have that, so that the court's doing something basic like just put the phone down so this conversation can happen and pick it back up. Right. And so I think those kinds of examples, some of these might be smoothed out in time, but we're going to watch additional things come into play that will be just the same but wearing a different costume.
Right. Okay, I think that's a good place to wrap up, unless there's something you think that we should let people know that we haven't talked about.
No, I think that does cover everything. Thank you, Kevin.
Excellent. No, thank you very much, and I will talk to you later.
Thank you so much for listening to this conversation. Remember to subscribe to the podcast. You can find us in Apple Podcasts, Google Podcasts, or most other major podcasting apps. Also, remember to follow us on Twitter at @CCR_U of A. And subscribe to our YouTube channel, youtube.com/C/Center for Criminological Research, so you can keep up with all of our great content coming out.